This is the American Law Journal.
PTSD, breakdowns, depression, we can suffer any type of psychological injuries in our lives, but what if that mental injury is caused by something that occurs on the job? Good evening, I'm Christopher Naughton. Welcome to the American Law Journal, and we're not talking about some slight by your boss or something your colleague said that makes you a little depressed. What we're talking about is actually pretty rare and can have some long-term, lifetime consequences. Gina Passarella with the Legal Intelligencer explains.
Jobs can be stressful or depressing.
I'm waiting on you!
But getting workers' comp for a mental injury, the odds are slim.
If you have a psychological incident at work where it has scarred you enough where you need to leave work, it's still the hardest type of claim to prosecute, in my opinion.
The standard in many states, including Pennsylvania, is that something out of the ordinary on the job must trigger that mental injury. Something highly unexpected. In fact, abnormal.
So it's something you observe or something you hear developing a mental problem in the individual. You still have to show that the environment was in fact abnormal, otherwise you'd have a lot of cases being granted based on one's subjective reaction to normal working conditions.
And what's considered a normal or abnormal working condition depends on the job.
So what do you do if you're someone who normally works in an abnormal sphere of life? Say a police officer who sees egregious things, a bank teller, a person at a check cashing agency, someone at a mini market in a bad neighborhood. How do those people recover? Well, traditionally it was very hard to.
Until recently. Two cases turned judges' heads. One where a mentally disturbed woman darted in front of a police car at night on Interstate 81. The woman flipped over the vehicle and landed on the highway. The officer gave mouth-to-mouth resuscitation while worrying about diverting oncoming traffic, but the woman bled to death. In another case, a liquor store manager claimed he suffered post-traumatic stress disorder after being robbed at gunpoint and duct-taped to a chair. Both men sought workers' comp for mental injury. Both were denied because, defense argued, these were not abnormal working conditions for their dangerous jobs. But on appeal, courts overturned both decisions. These men received their comp benefits. Yet in the world of mental injury, it's still the exception.
It's not the same as a broken foot or a herniated disc in your back. You're dealing with something that's harder to diagnose, but in most cases not any less real of an injury. Now it has maybe a little bit more of a chance, but there's still a ways to go.
For the American Law Journal, I'm Gina Passarella.
All right, three guests with me on the set tonight. Let's go ahead and meet them. George Badey joins us once again with Badey, Sloan, and DiGenova. Over 30 years trying cases in Pennsylvania courts of law and New Jersey as well, representing those injured in dangerous products, medical malpractice, of course, workers' compensation, and general personal injury. The Honorable Joseph Hakun returns to our program. Judge Hakun has been on the bench, let's just say, for decades. He is a contributor to the Pennsylvania Workers' Comp Yellow Book, and that's one of the most widely read reference books on workers' compensation in the Keystone State. And Barbara Young must have enjoyed her first time on ALJ because she's back again. I'll ask her after the program. Barbara hails from Schaff and Young, a defense firm, corporate insurance carriers firm, and Ms. Young has served as chair of the Philadelphia Bar Association's Workers' Comp section. 1-800-426-4625, the number right here in the studio. If you don't call early enough, you're not going to get your question answered. It can be on mental injuries. It can be on physical injuries that occur at work. If you're shy about getting on the telephone, email us at info@lawjournaltv.com. Well, it's interesting. This case that came down just a few months ago about a police officer. You saw Gina Passarella talk about it in the feature report. Police officer hits a woman at night. The woman hits his car. He gets out. She's bleeding from the mouth. He gives her mouth-to-mouth resuscitation, and then he's redirecting traffic. Now, again, in any world, one would think, oh my goodness, that's got to be a mental injury that you're going to get workers' comp for. And yet at first, George Badey, they didn't get it. He didn't get it.
That's right. I mean, I think the Supreme Court got it right. The Supreme Court is finally righting this wrong that's been around for decades, where if the judge says this was abnormal, this was a serious situation, mentally, it affected this state trooper's mental status, his ability to work, his ability to earn a living. And the Commonwealth Court said, oh no, police see all kinds of things all the time. That's not compensable. The judge said this was abnormal. So what the Supreme Court essentially did was right this wrong and say, we're going to pay attention to what the judge says. The judge in this case had a chance to see the dash cam video. The judge saw what happened, saw what the state trooper had to deal with, and I think the Supreme Court got it right.
I wonder how plaintiffs would have prevailed eventually if they didn't have that dashboard cam. You got to wonder. You probably wonder the same thing, Barbara.
I do, because I believe that it did leave a lasting effect, and I just wonder on a day-to-day basis how many dash cams and how many instances that we would see horrendous acts for troopers, police officers, and the like. And I believe that that's what they do on a day-to-day basis.
We love our first responders, of course.
We do. We have a special place for them.
But they are going to face some pretty stern stuff. I guess, Judge, there is a line that you can cross.
Yeah. The court actually in that case said, let's look at each individual, not each individual component, but the entire circumstance. For example, the court indicated that whereas the policemen, state troopers go to accident scenes and give first aid, that type of thing, you have to consider all of them together, not individually, not the components of the act, but the singular uniqueness of the situation. And in this situation, they found that it was an abnormal working condition.
Right. Well, and again, then the court just a few months later, good news again for the other side of the coin, Barbara, for the plaintiffs and the claimants, is that a man is working at a mini mart in the middle of the night. I don't know if it's a bad section of the neighborhood. I don't know if that makes much of a difference at the end of the day. He is basically has a gun pointed at his head. He is duct taped to his chair, and basically he files a workers' comp case claim, not based on any physical injury, but the fact that he has been traumatized at work. Now, again, I think the original court there said, no, we're not.
Right.
You work at a dangerous job, you're out of luck.
I think the thought was the state trooper case was an anomaly. It was something unusual. That's not going to be happening again. And then with the guy with the gun to his head, that was a store clerk, that was also compensable by the Supreme Court. Again, They said, well, gee, the Commonwealth Court said stores are robbed around here. Stores get robbed. That's not abnormal. Well, yes, it is. Yes, it is abnormal to have a gun put to your head like that. So now there's more precedent showing that there's a more reasonable approach to this where they're going to defer to the judge, who's the person on the front lines that actually hears the evidence. So this is a huge change in the law.
So if your client is a 7-Eleven or a Wawa or somebody who owns a mini mart, how do you now school or counsel your clients?
I'm going to instruct them to do as the courts have indicated in prior cases, that they're going to have to educate them on the strategy of handling these types of cases and to expect that this circumstance is going to occur. That because you're a clerk, because you're an officer, these are the types of situations that you're going to find yourself in, and you're going to have to make now the extraordinary ordinary.
Right, and of course, a prospective employer shouldn't be soft-soaping that anyway. It's like, oh, you don't have to really worry about stick-ups in the middle of the night. I mean, obviously, if you work, depending on where you work, and if you work in a mini-mart, that could happen. It may be a 1 in a million chance. I mean, do we look at statistics and say whether or not someone might actually be liable for someone who has got a gun pointed to his head?
Well, we're going to have to look at a lot of different evidence, and we're going to have to be vigilant in our investigation, both statewide and nationally, on how often this type of thing happens. I mean, the fact that in the trooper case that there's a term called suicide by cop means that this isn't an aberrant situation. It happens.
Well, the problem that I see, now Barbara's a great lawyer. We've had cases together. I respect her greatly. But when she said, we need to make the extraordinary ordinary, what we're doing is you can't make the extraordinary ordinary if it is really, in truth, and in fact, extraordinary. So I know that Barbara's a great lawyer, and she's going to tell her clients, train those employees to tell them that they're going to get robbed, so that when they get robbed, if they make a mental injury claim, we'll be able to say, we trained them, that's ordinary. It's not ordinary, and that's the issue. And do you listen to what the judge says? or do you let the appellate courts make these decisions and second guess the judge? I think that this is a really fair development, a fairness issue, where you're not trying to make the extraordinary
All right,
ordinary.
so the door's opened up a little bit again for someone who's got, again, for the lawyers out there, what they call a mental claim, a mental impetus, if you will, triggering a mental injury, as opposed to you hurt your back badly and now I'm depressed. Those kinds of what we call physical mental injuries are compensated a little bit more often. But let's go back to what I call the purely mental injuries. Another interesting case that comes down the pike: a woman is sexually harassed at work. A woman of color, they place a noose outside of a gym locker room where she could actually see it. They taunt her, they harass her, and there you see some of the facts up on the screen there. The only frog switch case, right? Yeah. The only African American female in the workforce of approximately 200 employees. There are the repeated incidents of harassment right there on the screen, so you can see how bad it is. And the court says, yeah, you know what? There's a mental injury for you. Reversed on appeal.
Well,
right?
Again, in this case, I think this is going to get reversed by the Supreme Court. I think frog switch is a case just like the state trooper case, just like the store clerk case, where you have the judge saying, wow, this is really extraordinary. It's wrong what they've done. They've caused a mental injury here to this woman, and the judge made those findings. The board affirmed it. Now the Commonwealth Court reversed it and said, there wasn't enough evidence. They found another way around it. And unfortunately, I mean, again, when we look at the political makeup of the court, you could see who reversed it, and the dissent in the court said, gee, we should have given this person benefits. And again, it falls on party lines.
Judge, do you think that this is going to, so obviously you got to get lawyers' attentions, because I think the case, rose and fell on the fact that they didn't have medical experts in this matter. So you can have a great case where you're mentally injured at work, but if you don't have the medical testimony of an expert, you could lose in the end.
That's right. The court specifically said, we're not going to determine whether this is an abnormal working condition or not. They found in this particular case that the medical evidence was not supported by substantial competent evidence, and that's why they didn't grant it. So it is going to become more important that the claimants prove their cases by proper evidence, that's strong evidence, because they're looking at this in a very close manner. It's interesting, though, there's also a very recent case that came out in the last couple of days, the Murphy case, in which was also a gun robbery, in which the judge had found that that even though it occurred, a gun robbery, and that the claimant was stressed as a result of it, it was not an abnormal working condition, and it's been remanded back to the judge to determine it in view of the Payes case of the Supreme Court.
Gotcha. Do you want to make a comment, Barbara? I knew before.
It is important that the medicine is, causation is made, and there's a relatedness to your psychological injury. The facts of the case are troubling. They're absolutely troubling. But not enough care was given to the medical component of the case. And it's a two-part process.
Unfortunately, if you read the dissent in the Commonwealth Court in the frog switch manufacturing case found that there was sufficient evidence, said there was a medical evidence that was certainly sufficient, and that the majority opinion written by the Republican judge said, we're going to split hairs here. We're going to undermine what the judge said because the doctor said this way, that way. They were super microscopic, critical of what the judge said.
And you think that the Supreme Court's going to take this case and overturn it?
I do.
I'm always amazed at how many workers' comp cases go up to the Supreme Court. We actually did that.
It's fascinating.
I think Paul Fires on the program said about 25% of the cases that the Commonwealth courts here are workers' comp cases.
Absolutely.
Boy, a lot of people getting injured on the job. We are taking your phone calls, and I just want to remind you folks, you can ask questions about mental injuries at work, physical injuries at work. We're going to take your phone calls from now till the end of the half hour, and then we'll stay around for another 10 minutes and take those phone calls. There's the number, 1-800-426-4625. Let's go to an email question, which I think kind of dovetails right along the lines of what we've been discussing. I've been the victim of both sexual and racial harassment at work. Not only my coworkers, but now I have a claim against my shift manager because he has become part of the problem. I'm suffering from headaches, nausea, and have trouble sleeping. I know I need to see a lawyer, but do I have any short-term recourse with workers' comp? From GP in Doylestown. That's an email question. Maybe there's not enough to move on that question.
The
but
short-term issue, that's one of the issues. That's one of the problems in workers' compensation, that if a person's injured that there's a process. If the insurance company says no, it's going to take several months at minimum to win benefits. So when you say short term, I don't know about that. There's no provision in the law for an employee to get quick compensation, whereas the other way, if an insurance company wants to cut somebody off, they have a process called supersedious. And if they come in with the evidence, within days they can get relief. I think that needs to be addressed by our legislature.
Very good. 1-800-426-4625. Let's get to some of your telephone calls. Eileen from Philadelphia is up first tonight. Eileen, what's your question?
Hi. A colleague and I were at work, and we were injured when an air conditioning fell on both of us. My injuries weren't that bad, but hers were pretty horrific. In fact, there was blood and bones, and I have nightmares from it. My doctor says I should stay away, but the company doctor says I'm better to go back to work at the job. I'm expected back next week, in fact, and I'm not sure what to do.
Are you receiving benefits currently?
Yeah, in fact, if you don't mind, I'm just going to hang up and watch on the TV, if that's okay.
Okay, but you are getting some benefits right now. So I think she said earlier on she's getting some benefits for the physical, but she's not. I think the question is also, is she going to get some help for the mental as well?
Well, that's a procedural issue. We would need to know, where is she in the process? There are a lot of questions that I would want to know the answers to before we can give any kind of
Gotcha.
guidance.
But someone who does get short-term physical workers' compensation, can they piggyback, if you will, mental? Does it have to be concurrent, or can you get physical and then also apply for mental benefits as well?
It's a causation issue.
Right.
Did the injury occur? Physical injury occurred. Did that physical injury ultimately cause some mental injury? And it happens frequently if a person is used to being very active and vibrant, and now they can't do anything and they can't support their family. Frequently they get depressed.
And oftentimes, even their primary care provider will provide whatever medicines or the like and document this in a chart. And then ultimately, George and I will have the fight of whether that should be an acknowledged injury, a bureau-acknowledged injury for which they can continue to receive treatment.
There's a lot of litigation on those issues.
Right.
Yeah.
Hey, Judge, in the state of Pennsylvania, where you once practiced, and again, you've been on the bench for many years, how easy or difficult is it for someone to bring a mental claim based on a physical injury? We talked about this at the outset of the program. I hurt my back severely. I'm away from work for weeks, maybe months. I get really, really depressed. Do we see those kinds of claims? I'm sure the insurance carriers and defense counsel fight them probably pretty rigorously, but how common are they, at least in your Commonwealth?
They're not real common. However, if you have the physical injury and the mental problem stems from that, it's much easier to recover. In a sense, what the court is saying in these kind of cases, that the physical injury kind of guarantees that the mental subsequent problem really occurred, that there's a guarantee to it. So we do see those kind of cases, and the physical, so this is a stimulus to the mental problem, can be compensable.
Okay, but still, I would think, George, and again, your firm has practiced personal injury for many years, Social Security, disability, those areas of the law. Mental injuries are more easily compensable, let's say. They're more easily quantifiable. Again,
Physical injuries.
Yeah, well, no, I'm talking about mental injuries, but mental injuries, in other words, Social Security disability, plenty of folks file because of depression. Let's put it that way. Personal injury, I get hit by a car. I might have some ancillary mental injuries. I mean, there's pain and suffering for that sort of thing. I guess what I'm trying to paint the picture is, when it comes to a work injury, the road to hoe for a mental injury tied to that is probably not that easy. But you're
mental, like we said before, and we don't want to confuse the audience.
A mental stimulus and a mental outcome, but a physical stimulus and then a mental outcome. How easy a case is that to bring and to prevail with?
You don't have to worry about this extra burden of the abnormal working conditions. If the injury, physical injury, occurred at work and it led to a mental injury as well, then you simply would put on the proofs as you would in any normal physical case. The issue that is unusual here is when there's a mental injury causing a mental outcome.
Right.
As the employer, though, we would really want to be concerned about past history and whether or not there had been prior treatment with reference to depression. Is there a divorce or bankruptcy looming that places a person over the edge.
Barbara's doing what what you have to do.
Those are the talking points that we would.
And that happens all the time, where Barbara will come in and say, "Aha, you are getting a divorce at the same time," and that's excellent evidence. However, the Workers' Compensation Act was designed to be humanitarian and remedial and to help injured workers. Right. And it also says if there is an aggravation or acceleration of a condition. So yeah, if you're getting a divorce and you're depressed as it is, and then you get a work injury that you can't even do anything to bring money into the household, that can aggravate the pre-existing condition. So right. Barbara's going to look for those things, and I'm going to say, okay, we'll raise you one, because it's a aggravation of the pre-existing condition.
All right, let's get back to your phone calls and some of your emails. Marlene, again, is she from Birdsboro? Marlene, good evening. How are you tonight?
Hi, how are you?
Good. What's your question for us?
I ran a jackhammer for 10 years, okay, and I did a lot of heavy work.
Okay.
And my question is, I was on workman's comp for 4 years, and I worked through every injury I ever had at work. I would just never take off of work whenever I got hurt at all. And when I got hurt, I was on workman's comp for 4 years. I went to all the best doctors. They sent me to Rothman Institute, the Jefferson Hospital.
Gotcha.
And all the doctors said I was going to be paralyzed. And so I have a pre-existing injury from jackhammering all these years, and it aggravated the injury, the last injury I had.
And what was the last injury? Was that also jackhammer related?
Actually, I crushed my finger in a ladder rack.
Okay.
And
so, Marlene, tell us quickly, where are you in the process, and where are you finding there to be a logjam?
What was that again? Sorry.
I'm saying, where are you in the process? Have you filed again for another workers' compensation claim, and are you afraid they're going to preempt you because of a pre-existing injury?
Yes, that's what they did.
Okay.
I had to file appeal now because they threw me off workman's comp now.
Okay, and that's not unusual.
Not at all, but again, this is one of those things where there are all kinds of little factoids that you need to know. What was filed? When they say threw you off, who threw you off? How did it happen? Was it by a judge, or was it by an insurance adjuster that says, oh, I'm sorry, we're not going to pick up this claim? People can't stop when the insurance company tells them no, because they always say no.
Isn't that one of the hardest things, though, Barbara, to really try to figure out, okay, is this injury solely stand on its own, or is the genesis really go back to?
Well, that's where medical experts really come into play, and why the medicine is important, because I'm going to send formal requests, and I'm going to ask during a deposition of George's client all the information so that I can subpoena records and determine whether or not, through the expert that I utilize, whether this actually happened while they worked for my employer or at some other time.
Gotcha. But again, but not an easy feat, though, Judge, right? And I imagine even for judges sitting on the bench sometimes, you've got to parse this really, really thin sometimes to determine. I would hope the tie goes to the runner, but I've got to figure that it's twisted you in knots a few times in your career.
Oh, sure. I mean, some of these cases hinge on very small facts. The medical's hotly contested in just about every case. And there's little nuances that take place to determine sometimes you win and sometimes you lose. So you need you really have to be fully prepared in a comp case.
Let's go to an email here from Philadelphia. I work for a sheriff's office after being punched in the face several times by an assailant being taken into custody in 2012, dragging a violent visitor in August 2013, and finally standing daily for not less than 3 hours, but no more than 8 hours a day. My legs began burning. I received a lot of physical therapy, but my doctor took me out of work for work-related injuries. The personnel director stated these were not work-related injuries and said I have a disability and I'm not fit to be a sheriff. I took family leave rather than quit or have them fire me. What are my options?
Well, I'm focusing on the section of the email said that my doctor took me out because these are work-related injuries. If that's what his doctor took him out for, and his doctor creates that nexus, that connection between the work injury, work situation, and his physical disability, then I think he needs to get a lawyer and file a claim. Because his supervisor says it's not covered, who died and left him boss?
Right, but what she's done is, I guess, buy more time by taking some family leave, which hopefully is not, I mean, obviously on its face, that should not compromise her case.
No, I wouldn't think so.
Right.
I mean, as long as he gave notice. I mean, there are notice requirements.
Right.
You need to give notice to your employer. But the sooner you get legal representation and the sooner you
Right.
move on your rights, the better off you'll be.
Right. And Judge, a good idea not to quit your job, right? Because let's face it, if you quit your job, the chances of you getting comp benefits after the fact are slim and none.
Well, if you quit for reasons other than the work injury, that's certainly so.
No, but I mean, if you quit for a work injury that's being contested, not unlike someone who claims that they're a victim of harassment, and then they claim a constructive firing after the fact, a much harder case to bring in a court of law or even with the EEOC. I would think it's the same thing with, I mean, I guess the question I'm asking is what this woman has done is she has not jettisoned her job. She's taken
Right.
family leave, so she's kind of preserved this notion that she hasn't quit, because once you quit, even if you say you quit because you've been injured, it still compromises your case, even if it shouldn't.
Right. Well, it goes to credibility, but the real thing is the medical aspect on it. If in fact somebody leaves their job because they're disabled because of the work injury, it's compensable, subject to proper proofs.
So where's this going? I mean, this is not going to open up the floodgates for George just because the Supreme Court and some Commonwealth courts have found in favor of claimants. And even though George believes that this one case where a woman really proved her case, sexual harassment and racism led to a mental injury, he believes it's going to go to the Supreme Court. But the floodgates aren't opening here. This is not, we shouldn't be expecting jackpot justice here, Barbara.
It's a lessening of a burden.
Yeah, I agree with Barbara.
It's a lessening of a burden of proof. But I will say, in the cases that you've mentioned, the state trooper, the liquor control board, and the manufacturer worker, all the judges at the judge level ruled on their behalf.
Right.
Yes.
So, I mean,
That's important. I mean, I think that, why do we have a judge? Why is Judge Hakun wasting all his time sitting there listening to all this evidence, and then he makes findings and an appellate court says, no, we're going to throw it out. The heavy burden is on the appellate court to say there's nothing that supports this. All facts must be construed in a light most favorable to the winner.
And unfortunately, Barbara, I'm going to have to end on that note. You'll get the next word the next time you're here on the program. Want to let you know we are continuing to take your phone calls in the studio after the show ends at 7:30. 1-800-426-4625. Continue to call in here. Thank you, George Badey, for appearing and, again, giving us the plaintiff's perspective. The Honorable Joseph Hakun, who brings those many years of experience to our table each time he appears. And Barbara Young with Schaff and Young, representing the corporations. Barbara, thanks so much for joining us tonight as well. For all of us here at the American Law Journal, thanks for joining us this week. Until next Monday night, case closed.
This week's American Law Journal has been made possible in part by Law Catalyst, legal media and marketing for lawyers. Go to lawcatalyst.com. Polanski and Polanski, former U.S. government counsel, representing those seeking Social Security disability benefits. Leventhal, Sutton, and Gornstein. We have your Social Security disability case covered. And the Legal Intelligencer, an American lawyer media company, and the oldest daily legal newspaper in the United States.